y'all. Welcome to The Presumption with me and Jim. Hi, Jim.
Hey, Sarah. How are you?
Good. How are you?
I'm awesome. Thank
you. Hey, Matt. Hey, Bo.
Hey.
Matt, do you even know what Bo is?
I feel like it's like boo or like a French word like beau, like B-E-A-U-X.
No, it's actually, Jim, you're supposed to teach us some Southern lingo. It's like boo in the South, I guess, right?
You know, the only boo I know is from Kill a Mockingbird. So,
that's right. Nice. Good ref.
We're used to Bo. Although I will tell you, I got a call from a movie producer not too long ago about they're making a Murdoch movie, and I was asking who was going to play me, and I suggested Billy Bob Thornton, and I really laughed about that. And I go, well, Billy Bob rhymes with Jim Bob, so why would you want Billy Bob to play
well,
me?
Let's now that we have a few episodes under our belt, everyone needs to know. I call Jim Jimmy G sometimes. Jimmy G because he's slick. He opens doors. He gets in trouble with judges.
I'm anything but slick.
Jimmy G. So we've got Jimmy G. We've got now you're Billy Bob Thornton. Do you have tattoos or something that you're hiding?
No, I got no tattoos. I got some scars. I promise you.
Right.
Yeah, plenty
Jim,
of scars.
if you're going to have somebody play you in a movie, this is really your opportunity to shine. You should have gone for like Pierce Brosnan, George Clooney. Let's get like a silver fox in here. You know, I mean, no disrespect to Billy Bob. You know, I'm just saying.
Hey. Billy Bob was married to Angelina Jolie, so no knock on him. No knock on him.
So you guys, a lot has been happening in the political arena, but it's legal. I mean, Jim, you and I, when we decided on what this podcast is really about and all that, we were very clear that despite our politics, we're going to cover everybody equally. If sometimes, because we're both white collar practitioners, if we have to talk about some sort of a Trumpy or Biden-y crime, that we would do it in the context of, legal analysis and not really based on politics. And so now today, this episode is going to get a little political, not political in the political sense, but whoever's email that was needs to be shut down. But in the sense of the law and how it applies irrespective of your politics. So on June 20th, the U.S. Attorney's Office in Delaware sent a letter to the court clerk, this is in Wilmington, apprising the court of a deal that has been reached between Hunter Biden, the president's son, and the U.S. Attorney's Office seeking an initial hearing. Remember that Hunter Biden has been under investigation, literally under a microscope, for 5 years, starting with during Trump's administration, for everything that, related to China. There was a lot of accusations about wrongdoings in China. And but then once they sort of opened Pandora's box, they were looking at everything and anything. And so this brings an end, essentially, this deal that he struck, to this 5-year investigation. So, Jim, you and I were talking about this. We don't necessarily agree with all of the sort of aspects of this deal, but he's going to be pleading to 2 separate informations. And information is, Jim?
I mean, it's a charging document. It's the same as an indictment. An indictment is passed upon by a grand jury.
Right.
Information, a defendant waives presentation of the charge to the grand jury and pleads to an information. Yeah.
So this is essentially because he has worked it out. This has always been the plan that he's not going to get indicted. This is like a pre-indictment type of deal. Right. And so the first information, Jim, is charging Hunter with 2 misdemeanor counts. I mean, we're both here to tell you that it's very rare to have federal misdemeanors. I mean, I've had maybe 3 or 4 in my 20 years. I don't know how many you've had, Jim, but most crimes in federal law are felonies. So this is 2 misdemeanor tax counts for failure to pay federal income tax. But since the time that he failed to pay, which was like 2017 and 18, he has apparently paid the taxes and filed his returns. The second information, Jim, charges him with a felony possession by a prohibited person because of his addiction to substance abuse or to substances, to illegal substances. So because of that history, technically he's not supposed to have access or possession of firearms. But the interesting thing about that is that this possession was for 11 days. And I literally had to put my glasses on to make sure that I'm reading the dates correctly. But apparently in the span of 11 days, he possessed guns and he wasn't supposed to. So Jim, I know the law was violated. Fine. I'm not saying, oh, that's slap on the wrist or whatever. But is it totally disingenuous of me to think that if he was not Biden's son, they probably would not go after him for this? This is essentially all they could get.
Sarah, I think it's too early to tell. I mean, I don't know that we really know all the facts, right?
Okay.
I do believe that if his lawyers had, they've negotiated a misdemeanor charge, 2 misdemeanor tax charges, and there were more serious conduct for which he could be charged, his lawyers should get a blue ribbon. I mean, they did an excellent job. If he had paid all the taxes and this was just a timing issue, then it is kind of it reeks of some political prosecution. So I think it's too early to tell.
But he did pay the taxes. He didn't file returns for 2017 and 18, and the investigation started in 2018. And but by 2021, he paid those taxes in full. And they were like, I think, around $200,000. But
so if you don't mind stopping there, I mean, here's the point: if a bank robber robs a bank, and then when he's under investigation for robbing a bank, he takes the money back to the bank. I mean, that doesn't excuse his conduct. And
that's true.
So if, 2017, 2018, he doesn't pay the taxes, he knows he's under investigation and he pays it in 2021. I mean, my clients don't get a pass. I don't get a pass, frankly. I mean, we got.
But you know what you and I do that I think is analogous to better than a bank robbery analogy, Jimmy G, is the idea that when you have a conspiracy, a fraud conspiracy, and you've got $2 billion of fraud, right? That everyone's sort of guidelines are calculated under. If your client, if Jim Griffin's client pays back, let's say, or doesn't even pay back, but you negotiate with the U.S. attorney on the case to limit the amount that was the amount that essentially determines his guideline calculation for the purposes of sentencing to the part that was his, right? So it's a matter of negotiation. And I think that given how it's not a lot of money to owe in taxes, it is for us, but generally speaking, in the grand scheme of things, $200,000 is not, the type of money that the government is like dying to get back. So I just feel like I'm not minimizing the crime, but I do believe that for all the people that are saying, oh, he got a pass because he's Biden's son, I think, no, there's possibly an argument to be made that he's getting convicted because he's Biden's son. Matt, can you play that? Can you put up the tweet by Kevin McCarthy? Because I want to see what Jim has to say about that. Kevin McCarthy's response to Biden's deal was that it continues to show the two-tier system in America. If you're the president's leading opponent, the DOJ tries to literally put you in jail. If you are the president's son, you get a sweetheart deal. I don't think this is a sweetheart deal. Do you?
I'm not sure, Sarah. I'm not sure. I don't know the fact. I will say this: the gun charge is total BS. I mean, I prosecuted cases in the 90s. I've defended cases ever since. I have never seen a federal firearms case be brought against anyone because they were addicted to drugs. I mean,
right, me neither. And you are a prosecutor. You are a federal
prosecutor. Oh yeah. And I haven't looked up the statistics, but I got to believe it's rare, and I got to believe it's extremely rare.
Well, former President Trump, responded on his platform, Truth Social or whatever it's called, The corrupt Biden DOJ just cleared up hundreds of years of criminal liability by giving Hunter Biden a mere traffic ticket. Our system is broken. The U.S. attorney that's behind this deal in Delaware, David Weiss, is a Trump appointee, right, Jim?
He is. But he's from Delaware, and the president's from Delaware, okay?
Okay, but what, I mean, all right, well, okay.
Sarah, I got to tell you, I agree with former President Trump on that point. It does give Hunter Biden protection going forward. That, the earlier episode, I pointed out that, the prosecution of Trump is a bad day for Hunter Biden, because when the Republicans get in office, they will very likely double barrel loaded on Hunter Biden. This protects Hunter Biden going forward.
Well, and I believe this. We don't have the information, and we certainly don't have the plea agreement, but I believe that there's probably some sort of language in there that goes to the finality of his investigation, because it went on 5 years, and this is all they got. So we were talking about the sentencing guidelines, and by the way, on the point of Donald Trump, we have a great guest in this episode, Mark Zaid. So we want you to stay with us, because Mark is going to talk about the president's own problems, which is way worse than this. Okay, so he really does a great job as a national securities lawyer unpacking the Trump indictment over the document case. But Jim, guidelines, right? You and I look to the guidelines to see how bad a trouble our clients are in. And so Hunter's guidelines, you and I don't agree on what the guidelines are, right? You're saying we're both looking at the tax table to come up with a figure and then to come up with the offense level. But you're saying he may have ended up in what we call zone B, which the range is for prison time over 6 months. And I'm saying, no, they negotiated a deal that put him in zone A because the prosecutors are recommending probation on these tax counts. So how did you calculate the guidelines for him?
The sentencing guidelines for tax cases, again, are based upon the amount of the tax loss. And as I understand it from the charging document, the amount of the tax loss is more than $100,000. The break in the sentencing guidelines is between $100,000 and $250,000.
Right.
And so, if you look at the guidelines,
level.
That's a level 16. If you plead guilty on a level 16, you get reduction
three levels off.
Acceptance responsibility, you get 3 levels off, and that correlates to a level 13, which is 12 to 18 months in jail. It's a zone C under the sentencing guidelines. Okay. And then we're getting very technical, but Zone C allows.
I feel like I'm at the airport right now. All these different zones.
So Zone C allows some flexibility as to, do you have to do all 12 months? Can you do them at home? And so you're right. You're at Zone C. You're waiting for your plane to arrive, and it takes a while to get.
I think he missed his flight, Jim. I think he missed his flight.
But I just know that the Uber is like on the other side of the terminal, and it just takes forever to get there.
Matt, that was well placed, and I'm just pointing out how boring the sentencing guidelines are, because they're extremely boring unless you're on the receiving end of those guidelines.
I think, look, from our experience, often prosecutors start with where they want to end, right? And so if they know that they are likely to give the guy a recommendation of probation, it's more, I think it just looks better in front of the court too, for them to come in agreeing to a guideline range that falls within that probationary type of sentence, as opposed to coming up with 12 months or whatever you're saying, Jim, and then saying, oh, but we want a variance for this reason or that reason. I mean, it's just cleaner. Not that it can't be done, but whatever it is, he's getting probation. He's going to have 2 misdemeanor convictions on his record, and we don't know what he needs to do to earn the dismissal of the gun charge, but that is not a non-prosecution. These are 2 different things. A non-prosecution is a gift with a bow that the government is not going to prosecute you. This is like, no, yo, Bo, you got to go do some stuff and then come back, and then maybe we'll then dismiss the charge. 2 very different things. So, Jim, what more do you think you need to know about this to be able to not be so murky and like Jimmy G's being the fair guy because it's a political guy?
No, I mean, just I want to know what the actual tax law says, and when did
Yeah,
when did he pay the taxes, when did he file the return,
right.
and did he do it before he was under investigation or after? I think that's a big difference.
Yeah, and I just looked at the dates for you said how ridiculous it was, the gun possession, October 12th, 2018 to October 23rd, 2018. I don't even know what kind of, was he in a hotel room when there was a gun? I mean, I just don't even know. I don't
Right.
understand how a possession could be so limited. Anyway, Zone C could also be my hair today, no?
Very
Not
nice.
All right,
all right.
guys. Do we have anything else, Jim, on
No,
this?
no, I think that's it. We need to roll into the next, I guess, to Mark Zaid, right?
Yeah,
Yes. So
let's
stay with us, right? Matt,
yeah,
are we,
and
okay.
if I may, I just want to get our plugs in for the guests, which is to say, if you enjoy these conversations, please subscribe on your favorite podcast platform. Watch the shows on YouTube, youtube.com/@thepresumption. At the Presumption's also our handle on Twitter, on Instagram, and you can email us questions, thepresumptionpod@gmail.com.
Stay with us and we'll be right back. And Jimmy G has promised that he's going to start rolling all those Southern, slang words, bad words, vocabulary, all the stuff that I know I'm waiting to hear.
Shit you up. That's the word of the day.
Hello, everyone, and welcome back to The Presumption with me and Jim Griffin. And our next guest is a very important guest because the case we're about to unpack is an important one. United States versus Donald J. Trump. And today we're joined by attorney Mark Zaid. Welcome, Mark.
Thank you. Welcome. It's great to be here. Thanks for welcoming me.
And Mark, you've probably seen on your TV screen a lot, and you've also probably seen his partner, Brad Moss. And if not, you see very wise tweets from both of them on Twitter. But Mark is a DC-based attorney. Now, Mark, listen, I'm not parsing out your bio because I was thinking about the indictment, Trump's indictment, and how he told one of his lawyers to pluck out the classified. So I'm not going to pluck out your bio, but I do want to hit on some of the more important highlights. So he's a DC-based attorney specializing in crisis management, complex litigation, primarily relating to national security, which I think is just so on point here, international law, foreign sovereign and diplomatic immunity, and the Freedom of Information and Privacy Act. He often represents former, current federal employees, particularly intelligence and military officers, defense contractors, and whistleblowers, and others who have grievances, have been wronged or are being investigated by agencies of the United States government or foreign governments, as well as representatives of the media. He has been a super lawyer like me, consistently since 2009 and received the highest recognition such as Best Lawyer in Washington Magazine's 2021 and 22 editions for his work in the area of national security. He's also an adjunct professor at Johns Hopkins University and has testified before a variety of governmental bodies, including the Senate and House Judiciary Committees. And like I said, you'll find a lot of wisdom from Mark, so I hope you follow him on Twitter. Now, Mark, you have a lot to say about this case and the charges against the former president. And Jim and I have a lot of questions. But first and foremost, what was your general knee-jerk reaction to this 38-count indictment, 37 of which are against Donald Trump?
Well, I was disappointed it actually took so long to bring to fruition. I mean, there clearly was activity by the grand juries, both in D.C. and Florida, and at least from what we know, maybe almost a last-minute transfer down to Florida where they had a concern about venue issues, which, from what I heard about the Supreme Court decision that just came out, might not have been as concerning as they thought, that they couldn't have brought it in D.C. And then refiled it in Florida if there was an attempt to move it. But it was basically exactly what we expected it to be in some variation of it. I mean, the facts that developed led us to where the indictment was. There was nothing in there that surprised me legally. I'd say the only thing that really jumped out at me that was somewhat of a surprise was the allegations that Donald Trump was far more personally involved in the process and interactions with the documents, which is strengthening of the legal case against him, than I would have suspected. I used to say all the time that, come on, nobody would have expected the president of the United States to have been packing up the boxes and looking through the boxes. I figured someone in his staff just took their arm and just, pulled across the desk, to fill all the boxes. But no, it looks like he was actually really involved with it. And then I wasn't expecting, and I'm sure the same is true for you guys, I have on-site storage, I have off-site storage for legal files. 30 years of law firm practice. I never had my file
Not your bathroom.
in a shower or a bathroom. Wasn't expecting that.
Well, the obstruction.
I know Jim looks like he's thinking he's not sure if he had his file.
Yeah, no. What I want to ask you, Mark, my Senator, Lindsey Graham, said this has got nothing to do about espionage. Why hasn't he been overcharged?
No. Senator Lindsey Graham knows better. He's held hearings, participated in hearings on the Espionage Act. The act, which is a century old, encompasses numerous provisions. It deals with straight espionage, what everybody thinks of as espionage. Robert Hansen, Aldrich Ames, James Bond type spy versus spy.
Yeah. Mm-hmm.
That's 18 USC 794. 793, what we're talking about, deals with the mishandling of national defense information, the unlawful retention, the unlawful dissemination to third party transmission, as I think the wording is, to third parties. Has nothing to do with spying. It's just the name of the statute. I was on Laura Coates's Sirius XM station. Laura, as you know, was a former prosecutor. And when I said this, because this question comes up a lot, and I said the answer, and she's like, I've had the same thing. She's like, I used to prosecute some folks, and it was some sort of theft statute. And in the statute, it referred to farm equipment in the title. And the people would say, what are you talking about? I didn't steal any farm equipment. And it's like, no, nobody said you did. It's just the name of the statute. It's not what the statutory provisions say. Look at the provisions, not the name of the statute.
Well, and the Trump allies and supporters, and a lot of, he's got a lot of lawyers and former lawyers who come on TV and say, oh, it's a rusty statute. It's unenforceable. But to your point, Mark, what stood out to me is, well, first of all, this is the presumption podcast. Even Donald Trump is entitled to be presumed innocent until the government proves him guilty beyond a reasonable doubt. It's just that, for all of us who practice and have done this kind of work, looking at his federal indictment was shocking to me. Not because, I expected it. I was saying that this is probably the most imminently indictable of all of his, pending woes. But it was the level of detail, and it really was the obstructionist conduct. I was, like you said, he had a death grip on these boxes and these documents to the point where he didn't even want lawyer number one to show up without him being there to go through these boxes. So, but I did, look, if Joe Smith, my client, got the same indictment, at first, it looks a bit inflated, right? It looks like one count after another, 30 plus counts. It's the same 793E. It just, they parse it out as to each classified document having its own count. And Mark, you mentioned that, about the 793E charge being different than the 794, and that's unlawful retention, which is what applies here. When you say unlawful, you mean the willful retention, right?
Yes.
Okay.
Yeah.
So what are the elements for someone who doesn't know what 793E prohibits? What are the elements of a violation of 793E under the Espionage Act?
Sure. And let me walk sort of an introduction into what you were talking about. The Espionage Act, like I said, dates back 100 years. It hasn't been amended in 7 decades. So, for example, it does not speak to classified information because it was drafted prior to our current framework for classification purposes, confidential, secret, top secret. It refers to national defense information. Now, we can talk about that the Act doesn't even require information to be classified. It requires it to be NDI, national defense information. For all intents and purposes, they are identical nowadays, but they don't have to be. But I never imagined, and they haven't, where they would have charged a former president of the United States with possession of national defense information that wasn't classified. And we can get into more details with it. So there are a lot of criticisms of this statute. You rattled off a few adjectives about it that are common. It's clumsy, it's antiquated, etc. But what I will say to that first is it is rarely used. We hear about the cases a lot because those cases that are brought become high profile. Either they are a real spy case, which is always going to be very prominent, like or a leak case like Airman Texera that is in the news right now, or a leak to a journalist, of which all the media obviously focuses on. But statistically speaking, the number of potential leak cases that could be brought or mishandling of classified information, it would be in the hundreds, if not thousands of cases every year. I handle mishandling of classified information cases all the time. It is rarely criminal. It is usually handled in the context of administrative matters, security clearances, and or termination from employment, whether contractor or federal civil servant. Because it doesn't need to be handled criminal, because it just doesn't arise to that type of mens rea of intent, etc. So I don't want this act to be modified. Goes a little bit to what we were just talking about the title of it, because one, I have no faith Congress could modify it in a way that wouldn't screw it up worse. And it would also create any number of legal problems of new litigation to define or interpret what the new language is in the statute. So because it's used so infrequently, just let it lie. And the reality is, and this starts to go into the specific question you just asked, very few Espionage Act cases of this nature, of mishandling, ever go to trial.
Right.
Because they are, one, dealt with in pre-trial aspects. Most of the real fight will be in the pre-trial motions. And by the time the cases go to trial, they are so whittled down and so narrow in scope that the defense doesn't have a lot of wiggle room. It really only gets down to, in a 793E case in particular, did the person do it or not? So meaning in Trump's case, if Trump could mount a defense that went, what are you talking about? Those documents weren't at Mar-a-Lago. They were never there at Mar-a-Lago. I never took the documents.
Well, you can't do that.
Can't do it, right? I had a case where I worked on Jeff Sterling, who was a CIA case officer. He was prosecuted. He was convicted, served 3+ years in jail for leaking information, classified information, non-national defense information to the New York Times. Jeff still, notwithstanding having been convicted, claims he did not leak that information. So that went to trial because that was a defense. No, I didn't do it. So in this case, and there are multiple provisions even within 793E, and anyone who reads it is going to get a headache. I mean, I get a headache when I read these statutes. To put it in an easy nutshell, it is: were you determined to have possessed national defense information? Let's just make it easy. A top secret document, and we, the government, said, you have that document. We know you have that document. You need to return that document, and you don't return the document. That is the essence of this case.
We have a lot of that here because for
a lot of it on multiple occasions. And I will say, and then I'll swing back to allow for the questions. If Donald Trump had handled this case the same way that President Biden and former Vice President Pence had handled it, meaning we discovered we had marked classified documents, we notified the government, we gave them to you right away, that would have been it. We never would have had a prosecution. Even if it had been any time before the execution of the search in August of last year, even after the lawyer had executed, lawyer one, I think, had executed the declaration, the affirmation, attestation, however they labeled it, in June of last year, if they had returned everything and there had been no evidence of obstruction or conspiracy to obstruct, we wouldn't be here right now. There would be no criminal prosecution.
Well, I think the obstruction also.
Whoa. Now, Mark, that's your opinion, right?
Okay.
I mean, that's your opinion. That's not a fact. And I think a lot of Trump people would say, oh, yeah, we would be here right now because this is a political prosecution. And Trump, all the information that he's accused of not returning, I mean, he could have had it all in his head. I mean, he was entitled to the most secrets of the U.S. government. And so, you know, I mean, as Geraldo says, you know, you're charging him 400 years of potential penalties for not returning a library book.
Right. Let's put that tweet up from Geraldo, who, you know, this is just before the indictment came out. So we knew that Donald Trump was indicted. Geraldo put out a series of tweets, and then eventually, a few days later, the indictment was unsealed. But the one, Matt, that says, where he says, this is the equivalent of something about borrowing a library book that you forget.
Yep, got that one too. One sec.
Yeah, and look, for a lot of these cases, all we can do is go off of past examples, anecdotal examples, some of which nobody knows about because we handled the case and there was an outcome. Other cases that were become, you know, very, very public.
Yeah. So Mark, look, it says, I have made it clear over the last several years that I will never, ever support Donald Trump running for president of the United States again. But I absolutely agree with him that the documents case is an inflated political prosecution that is unfit for American public life. It's like someone forgetting to return their library books and the cops coming to retrieve them. It is bogus, embarrassing, and ultimately will help him more than hurt. It is a pity we wasted so much time and energy on so superfluous an exercise of random government power. Agree, disagree, why?
No, he's factually just completely wrong. It's not like forgetting a library book. You know, I have had cases where, and this is the common mishandling case, somebody retires from the government, they pack up their office, they bring it home, they stick the records in the file boxes in their garage, and then at some point later on, they go through it and they realize, oh, shoot, I took home some classified documents with me that were either under the stack or in the middle of it, and they reveal that on a polygraph or they bring it into their security officer. Those folks don't get prosecuted. They may lose their security clearance. They may get fired. They don't get prosecuted. They didn't know they had the documents. This was, even looking at all the facts, and it's not conjecture because the facts are the facts. And we have what his admissions are. We have what his lawyers are. And they obstructed the federal government's efforts to retrieve these documents. Now, I'm not going to accept everything that the federal government said. They're going to have to prove a whole bunch of what they said, obviously, in the indictment with respect to that his aide took 60 boxes upstairs, only returned 30 boxes. They say they have that on video. Okay, fine. We'll all see that, right, to be the case. And we have all this other stuff. We'll see if the attorney-client information survives a motion to suppress as to whether or not that should have been pierced in the crime fraud exception. Not necessarily going to survive. That could be a completely different ruling. But had I been representing someone who was a GS 13, 14, 15, these are senior management officials in the U.S. government, or a contractor, and had the same fact pattern, my client would have been indicted over a year ago. They never would have had the opportunity to go back and forth with the government about this. They would have had their home, they would have had it searched way earlier and been indicted. If anyone has received preferential treatment, actually President Trump has. It's been more favorable for him, not less.
By the way, next time you have to say shoot, you could say shit, because this week
Okay.
drop the F-bomb and everything here.
So Mark, you mentioned earlier that this Espionage Act hadn't been amended and changed in 70 years. It's a rusty law, but we do have a more current law. This is the Presidential Records Act, and we're dealing with a president. And the Presidential Records Act has no criminal penalties associated with it. I mean, shouldn't the more current law being applied to Trump, and his supporters are saying that? I mean, that's just not a frivolous claim, is it? I mean, that's something that's a good faith issue's never been addressed, correct?
Look, there are going to be a lot of pretrial motions that address issues that have never been addressed. Like, I heard one of Trump's lawyers, who actually I have cases against right now, including against President Trump for January 6th, but I've been up against him a bunch of times. And he claimed that the Espionage Act is trumped, pun intended, by the Presidential Records Act. Now, I think that's a ridiculous argument, but it's never been tested before. So, hey, it's a. Is
this the guy that was on Cuomo with Renato Mariotti, and Renato couldn't keep a straight face? Yeah, because he couldn't even articulate what it is. He kept saying it's the Presidential Records Act, but he couldn't articulate what that is.
No. Now, there are no criminal provisions in it. Right. Yeah. But this statute was designed to avoid exactly what we're talking about now. I'll tell you a little bit about the history, because in my library downstairs where I am, I have a formerly top secret document from the Truman administration. Nicely framed. It's a CIA telegram to President Truman and a letter from President Truman about China's nuclear weapons programs. Because prior to the Nixon administration, or really prior to the Reagan administration, but because of Richard Nixon, White House records, anything created inside the White House, was deemed personal. They took them all home. So this document was actually in the possession of Truman's chief of staff until the mid-1990s, when he turned it over to the government because they wanted to sell what they had. And they made a deal that if it's classified, the government keeps it. If it's now not unclassified, declassified, it gets returned. So I have this really cool original telegram. The Presidential Records Act was created during the Carter administration, took effect with the Reagan administration. It makes it clear what is and what is not a presidential record. It's really black and white. Anyone who reads this statute should not be debating, is it a presidential record or not? If it were this Clinton tapes, you hear about it in the sock drawer, he created those tapes himself. That's why they were deemed personal. What we're talking about in the Trump case are agency records, CIA, FBI, Department of Defense, other agencies that came into the White House through official channels for him to review, assess, whatever. So I'm perplexed by anyone who thinks that they wouldn't be presidential records, which means by the statute, the next day or the day of inauguration, when we are supposed to have this peaceful transfer of power, the U.S. government owns those records, plain and simple. There's a reason why there's no mention of the PRA in the indictment, because it's not relevant. It's not relevant.
Mark, I don't want to get too deep in the weeds here, but the example you just gave about Truman and the confidential or information about Chinese nuclear project under the Presidential Records Act, you're saying that would be a government property today. Now, yeah, and if Truman had kept that at his house today, then he'd be prosecuted under the Espionage Act. What I'm hearing, but so what makes it espionage crime under today's prosecutorial theory is the Presidential Records Act. Does not carry a criminal penalty. And so
no, it's the notion of he still would not have been able to have classified information in his possession. The Espionage Act and the Presidential Records Act do not go in sync with respect to that.
They're not mutually exclusive, is what you're saying.
They're not mutually exclusive. Yeah. What I'm saying, from a policy perspective, they used to take everything home, including classified information. They weren't supposed to. It was never supposed to be that.
When you look at Trump's indictment, there are three categories of documents. There's confidential, secret, and top secret. Yes. and Jim did the guideline calculation. It's always a fun exercise for those of us who are federal practitioners. And I did it with a colleague of mine down here who's just been fascinated by the story. So it's up there. I mean, he's up there. That doesn't mean that that would be a sentence he would get if he were to be found guilty of these of the charges in this indictment. But before we get to what your thoughts are on sentencing exposure, what is the difference between these documents, just briefly, for folks to understand? Does that mean it's any worse in terms of exposure? Does it, why that distinction? Because there is a distinction in the indictment.
So there's an executive order that sets forth that the current one is from President Obama's time in 2009, that, and this has remained the same for decades, that sets forth the level of damage that is expected to occur with the disclosure unauthorized of different levels of document: confidential, secret, top secret. There's also references to different compartments in the indictment. When you hear the notion of TSSCI, top secret, sensitive, compartmented information, SCI is a separate compartment. It's not a classification category by way of clearance. Like I hold TSSCI eligibility. That means the best way to describe it, just for people's as a layperson kind of explanation, if you have a key to your house, entry into the house gives you access to all the confidential information. If you want to get down into the basement, you need a key for that door. That gets you into the secret sphere. If you go in the basement, you go into your utility room and you want to get access to that, you need another key. That's your top secret. It's getting smaller and smaller each time. Once you're in the top secret room, there's a safe, and you want to get access to that. That's your SCI. So the higher the level of status, the greater damage that is presumed by its release. I have never, frankly, understood, like, one is exceptionally grave versus grave. I have no idea how to define what the difference is, to be perfectly honest, other than you can say for much of the SCI type information, we're talking about sources. If a human source could be revealed by the document and therefore possibly killed, that's within an SCI category. You're not going to see that generally at a secret level. I mean, look, the secret level could literally sometimes be newspaper articles that the government got a hold of and factored into their analysis for a variety of reasons. That's obviously not what Trump's being prosecuted for. Now, I will say, just to note,
but there were newspaper clippings in a lot of these boxes.
Oh no! There were, but that's not one of the 31 documents.
Right. That's true.
One of the 31 documents is labeled as formally restricted data. Now, that's important because when we get into the notion of could he have magically declassified this information, which again is not really relevant actually under the Espionage Act because it's national defense information. And in any event, in Espionage Act cases, you don't get to challenge the classified or classification nature of the documents. But that one document, that was chosen very specifically because formally restricted data, and it pertains to the U.S. nuclear weapons program, that is a category of classification under the Atomic Energy Act, which Congress passed back in the 1950s. By statute, the President of the United States actually has no authority to declassify that information. Only the Secretary of Energy or their designee has that authority. So even if he said, I thought in my mind I declassified everything, which is just not how the system works, but we can talk about that a little bit further if you want, it wouldn't apply. His mental powers could not encompass that one document.
So that's not a defense, obviously, from what you just said. The fact that I didn't do it, which is a defense in certain cases, doesn't apply here because, I mean, there's ample evidence that he was aware that he was retaining these documents. But we have a video clip we want to show you from his speech at Bedminster, where he has a home in New Jersey, following the arraignment. Matt, can we play that video real quick where Trump is essentially asserting a potential defense?
I hadn't had a chance to go through all the boxes. It's a long, tedious job, takes a long time, which I was prepared to do, but I have a very busy life. I've had a very busy life.
Is that a defense?
Sure. Well, look, it's a defense. It's like when we're asked by a prospective client, "Can I sue?" And we go, "Yeah." And if in federal court, if you have $402, sure, you can file the lawsuit. Oh, do you want to know? Could you win? Oh, okay. Different
Right.
question here and different answer. All right. So that notion of, well, I didn't have the time to go through it. I didn't know what I had. Obviously, the government's going to have to prove these facts, but at least the facts, as we have been told they are, is there's communications between Walt Nauta, his co-defendant, and him, President Trump, about taking the documents from where they were located and bringing them up into the residence. There were documents found when the FBI searched his residence in August of 22 in and around his desk, specific classified documents. And it just seems somewhat ironic that of the boxes that went upstairs or wherever it was in the mansion and then came back to the room where the lawyer, Corcoran, was able to search, that the bulk of the really classified documents weren't among those, right? It gives the appearance, at least, that these documents were looked through and, as we keep using the term, plucked through somewhat. Now, it will. There's also no coincidence that of these 31 counts, and I will say in response to what you had mentioned actually earlier, this could have been one count under the Espionage Act. Absolutely. Could have been charged that way. It could have also been 300 counts to encompass each of the documents that were discovered or returned back. How they came up with the 31, we can conjecture. I have thoughts. I don't know, if I would be right or not, but at least I have some thoughts about why the 31.
Like why?
Well, we talk about the Goldilocks documents. They're not so sensitive that we're concerned as the government to disclose. And they're not so weak that if you looked at them as a layperson, you'd go, really? Because I deal with classified information all the time. And I can't tell you what it is because it's classified, and I'll go to jail under the Espionage Act. I can tell you a lot of times when I look at the classified information, I go, really? That's what you put down as classified? That's pretty ridiculous. I had a judge once. I sued the National Archives and the CIA for the oldest classified records in the United States. It was invisible secret ink formulas from World War I. They were 90 years old at the time. And the judge that I had in D.C. District Court, one of the first things he said to the government was, "Didn't I get these formulas in my breakfast cereal when I was a kid?"
Right.
And I mean, so you don't want either of those extremes. These 31 documents are probably documents that when the jurors look at them, and the jurors don't need security clearances. It's also a very strange situation. The lawyers, we need it. I've had to get cleared for criminal Espionage Act cases, but the jurors don't get clearances. They don't have to sign NDAs, non-disclosure agreements. They'll be admonished by the judge. You can't disclose this. This is sensitive information. I've never seen a juror get prosecuted for saying anything after one of these cases. That would be pretty interesting. But these are documents that I think that the government culled so that when someone looks at them, they'll go, "Oh yeah, I could understand why that's classified." But it won't be so sensitive that the government is concerned about sacrificing the information.
So Jim, before you go through the guideline calculation, and Mark sort of gives us his thoughts on a potential sentence if Trump were to be found guilty. For folks out there, federal sentencing is essentially you look at the statute, if there's a mandatory minimum, which doesn't apply here, and then you look at the maximum. And then you can't turn around and tell Trump or any client, hey, it's up to 20 years or it's up to 10 years. You still have to look at the guidelines to do a calculation of the range of sentence that applies to them, which is what I'm talking about Jim doing, and I did with my colleague. So Jim, what are Trump's guidelines based on this indictment?
So basically the base level guideline, because these are top secret documents, is a level 35 in the sentencing guidelines, which correlates to 17 and a half years in prison. If you start adding upward adjustments for breach of trust and obstruction of justice, you get over, low 20 years, 22 to 24 years, which is a lot of jail time under the sentencing guidelines. I don't for 1 minute think that practically he's looking at over 20 years in prison, but I'd be curious to know, Mark,
So what is he? Yeah,
what people are getting in these type cases.
So historically, for mishandling and leak cases, it has ranged from about 3 to 9 years. One of the most recent cases was that of Harold Martin. He was an NSA employee, and he was a pack rat. He hoarded thousands and thousands of, I think he even had like terabytes on thumb drives and other things at his house. No evidence that was publicly shared that he was looking to sell it, transfer it, leak it. He just had it at his home. He got 9 years. That was a long time. Chelsea Manning, who I represented recently to help her get her book properly cleared for classification purposes, Chelsea had been sentenced to 35 years. Now, that was in the military system, some different standards that apply, multiple counts, and that was a leak case, right? Turned over the information to WikiLeaks. It got disclosed to the public. She had her sentence commuted by President Obama at about 6 or 7 years. Reality Winner got about 5 or 6 years for leaking one document. But most of the other cases were like 3 to 6 years.
But Mark, here you have the obstruction, which is really the most nefarious part.
We'd have to add that on. We'd have to. Right. So I don't pretend to be a criminal defense lawyer other than playing one on television, where I get brought into specific cases to deal with the national security component of things. So take my view on this for what it's worth. But I look at myself, those of us who practice in DC, everything we do, especially my type of practice, gets impacted by policy, politics, and the law. So I'm factoring in all of those type of situations my prediction would be, were he to actually go to trial and get convicted or plea out, which would be normally what would happen, although I don't see that as very likely for Donald Trump. And we can talk a little bit more about that. I would see this as being let's say 6 to 15 year sentence.
Wow.
He's 77 years old. That's going to be taken into account. He's a former president of the United States. That's going to be taken into account. I said this on Twitter the other day.
Also, you know what? I mean, Jim and I have not talked about this, but it just came to me. Relevant conduct at sentencing, relevant conduct, like aggravating factors like January 6th stuff.
Oh, there's a ton. I mean, there's a ton. But realistically, for, a man of that age, the stature, I mean, I think you got to be talking jail time, but you're going to be talking, but then these numbers are making up. If I say 3 years, 5 years, 10 years, 15, it's going to be somewhere within that range. But I wouldn't be surprised that if you get a Republican president, not him, because he'll pardon himself, but I could see any Republican president, whether it's in 2024 or 2028, pardoning him.
Yeah.
And quite frankly, I can see a Democratic president, maybe in 2025, 2026, commuting his sentence, not pardoning him, but commuting his sentence in the same way that President Ford did for Nixon for the betterment of the country. It's not a good look to have a former president of the United States in prison, especially in a divisive world or country that we live in right now. And I will tell you, having been subject to death threats because of the work I've done involving President Trump and having people prosecuted for it, and being here when January 6th happened, I think we're just in a lull.
What about the timeline here? I mean, you're talking about, obviously there's a political issue of the election, and this case is going to go a long time. I mean, it would normally anyway, but specifically because of the classified nature of the document. So Jim and I were like, how does, as lawyers, do we get to see that discovery? I mean, normally we get the evidence in a case. Or sometimes the prosecution tells us you can come see it, but you can't walk away with it. How does discovery work in a case like this?
So you saw the first order that Judge Cannon issued was to push forward on the defense lawyers becoming cleared, receiving their security clearances.
Okay.
None of them have clearances at this current time. They have to, so far, 2 of them have notified the court that they have asked the government to start processing them. Those are the 2 primary counsel. Presumably, and frankly, hopefully for President Trump, he'll find counsel who has experience with classified information and the Classified Information Procedures Act, CIPA, which a lot of the pretrial motions will pertain to. There's not a lot of lawyers out there who frankly have that experience, much less in Florida, but hopefully he'll find somebody. But they'll have to fill out what's
So he needs a CIPA lawyer for this, not just a regular federal criminal defense attorney.
Yeah, I mean, clearly he needs a seasoned, experienced federal criminal defense lawyer, but there will be a lot of pretrial motions. Look, maybe it won't make any difference at the end of the day, because quite frankly, I think what the defense team and strategy is going to be is to just delay this case out as long as possible. Come up with any pretrial motion that is feasible. And in some ways, sometimes that means it's better if you're not experienced in the statute. So you don't already have an idea of, I know this won't work, I'm not going to try it. Rather than someone novelly looking at the statute and going, well, I'm going to challenge that. I'm going to challenge that. I'm going to challenge this, and just drag out the process. But the defense lawyers will need to be cleared, whoever will have access to the classified information. I suspect if I were them, I would ask for access to all of the classified information, not just the 31 documents. I want to see it all, because I want to understand why the government didn't charge for the other gold document.
It's always like context, the idea that context matters.
Context matters.
In defense, we always bring in the context. It's like prosecutors focusing on one phone call and, oh my God, this is incriminating. It's like, no, it's not when you look at the other 90 phone calls.
What was the phone call before and the phone call after?
Yeah. I just want to try to get Jim in on this as well as we're wrapping things up here. Jim, any final thoughts on, are we really looking at former President Trump going to be in jail? That's going to be wild.
No, I couldn't agree more with Mark, what he said, that the end result is he gets pardoned or commuted. I think they drag it out long enough until a Republican is in the White House and he gets pardoned eventually.
I have a question for both of you. The whataboutism.
With Hillary and Biden and Pence?
Hillary, Biden, and Pence.
They're very different. Jim, if you want to.
No, I'd like to hear your take, but honestly, I'm not 100% convinced this was the correct exercise of prosecutorial discretion. Frankly, I think because of those other issues and the public criticism on DOJ, because why didn't you go after Hillary? Why didn't you go after, a lot of other things? And now you're picking on Trump, and so and I think the end result will be a political result in a pardon or commutation. So I'm not.
But don't you think to me, that tells me that this case was so damn strong that they had to do it, legally speaking, that they had to kind of just for just as unprecedented as it is, set aside the political considerations and what it does to the country and what DOJ typically does, like Jim, you're saying, and be like, we cannot not indict him. That to me, I'm hoping, I don't think they did this frivolously or swiftly, or like Mark said, I think they dragged their feet doing it. So I think there's something there, at least I want to believe, that not only they have ample evidence, and that, like Mark said, I want to see what else they have, that all those boxes will check out. It's almost like a situation where if we're going to sit here and say, I'm an immigrant, right? We came to this country for its freedoms, and the idea that no man is above the law. I mean, I wrote a book, for Trump's campaign crimes, thinking that's the beginning and the end of his stuff, but clearly not. And the idea that no man is above the law in America. I mean, if the DOJ doesn't charge him based on what we've just taken a glimpse of in this indictment, then I mean, that's not really a principle.
Well, in America, we don't jail our political opponents either, and so that's the rub here. That is the rub.
But we do have to jail our political opponents who commit crimes. I mean, that's what it comes down to. We don't jail our political opponents because they are our political opponent.
Yeah.
That we don't do. And I don't think that this case is one on the fence. I agree with Fox News saying what a sad, tragic day this was on the indictment. And then I agree with, or I say, what a great day it was, not because Trump was indicted. That's not a good thing that a former president was indicted. It's a good thing for the rule of law that we don't treat someone at that level any differently than we would my normal 32-year-old GS-13 client.
No.
And again, going to the question that Sara was asking about the whataboutism, I firmly believe, and I know a lot of the people involved, especially at the archives. I don't know the prosecutors, at least not the primary ones. The Pence and Biden cases are a perfect example of how it should have been and would have been for Donald Trump if he had just returned the documents. He could have, including under the Presidential Records Act, if he had returned everything and said, "You're wrong, U.S. government, those are my documents." He could have then sued under the Presidential Records Act as a civil action and challenged that all those withholdings or the seizure of it, rather than holding on to the classified information. And understand, of course, the search, the subpoena for him, the warrant, not warrant, the search warrant, but I guess the subpoena, I'm trying to remember what was issued, was for documents that were marked classified, not classified documents. Meaning, if it said top secret on it, you had to give it back. It could still be unclassified. Now, Hillary Clinton case is an incredibly different case. And it's not very well understood. I was all over her at the time of how idiotic it was that what she did, and even more so her senior staff, that they allowed her to do this. How did you not know this was inappropriate to do, just as a matter of course, to have a private server where you're communicating outside of U.S. federal government systems when you are the Secretary of State? But if you look at the thousands and thousands of emails that she had, for one thing, if you indicted Hillary Clinton, you had to indict dozens of other people, because it wasn't just Hillary email. It wasn't just her. There were multiple people.
Yeah, that's right.
And you couldn't discern why would one person be guilty and another person not be guilty. And they weren't marked classified. There were some emails, I want to say like 11, that had confidential, a C in the middle of the body of the emails. Because what was happening is, like we all know, you hit reply all and you grab
all the whole thread. But also, Mark, she cooperated. What I keep saying about all of these people, and it's interesting that we have Democrats and we have Mike Pence too. It's not just one side, right? All of them, as soon as they were aware that there was a boo-boo, right? They cooperated, they returned. That is the problem here, is that Donald Trump essentially told the National Archives to take a hike, told the DOJ to take a hike, and they did what they really didn't want to do, which is to do it the most intrusive way, by getting a search warrant.
And anyway, the final point on that I'll say, though, is it was also a different provision that they were looking at with respect to Clinton, not 793E. They were looking at whether there was gross negligence in the mishandling of the documents. And when I say Espionage Act prosecutions are rare, I'm not even talking about that section. That section has barely been used in the history of the act. There's like 3 cases that have been identified, I think 2 of which, if I remember correctly, were military. Yeah. And the fact is, the definition of grossly mishandling or gross negligence, I think it is, nobody knows what it is. It's not well defined. So are you going to bring a case against a Secretary of State or a former president of the United States on a statute where the terms haven't been well defined or interpreted?
Gross negligence is always murky. Gross negligence, even, when you're talking about a street crime, it is murky. When is it ordinary negligence? When does it cross over to gross negligence? But when you say willful retention, and you have obstruction going along with it, and tapes.
That's what makes a difference.
That's what makes a difference. Mark.
I have been battling DOJ investigators, prosecutors for 30 years. I am not ready, I don't think Sara is, or probably you, Mark, just to say, oh, they got it right, and there's no reason to look behind this. I think maybe the big loser out of this is the American people. And I think maybe the next biggest loser besides Donald Trump is going to be Hunter Biden, because they're going to come after Hunter Biden as soon as Republicans get in the DOJ. So,
hey, and if he violated the law, and I've said this publicly, go after him. Let's prosecute him. But look, I'm with you. My entire career, 3 decades, has been against the U.S. government, or representing people in the government against the government, employees, CIA case officers. I don't trust any of those agencies. I work with them. I respect them. I'm fully in support of the military, law enforcement, our intelligence community. But yeah, they've got to prove their case, including against a former president of the United States. And they better do so.
Mark, we so much appreciate you coming on. I do want to get up with you later, since you have had all this exposure to classified documents, and find out, are there UFOs out there? That's really what I want to know.
I've handled that case before. I was saying, if you ever saw the 97-98 movie Contact with Jodie Foster, I'm a big supporter of that film, and how it ends, where she says, if there aren't alien life around, it's an awful big waste of space.
Mark, thank you so much. I hope that you stay in touch and join us again as this case unfolds. I think we're in for quite a ride, so we'll rely on you.
My pleasure. I'd love to come back.
Thank you.
And Sara and Jim, I guess it's time you guys rest. What do you say?
And until the next episode, Jim, we
rest.
We rest.